The Assisted Decision-Making Capacity Act 2015 marks a transformational change in Ireland's capacity law. It will improve decision supports for people who are in some way lacking in capacity, either currently or in the future. There'll be a focus on will and preference rather than the traditional best interest test, and there will be 5 types of decision support under the new Act. The first is the lowest level of decision support. That's a decision-making assistant, and it's someone who is appointed to assist a person who is making decisions on their own behalf, and it's assisting them to make the decision. The second tier is a co-decision maker. That's someone who's appointed to make decisions with a person on a joint responsibility basis. The third type of decision-making support is a decision-making representative. That's where the court appoints a representative to make certain decisions on behalf of someone who is lacking the capacity to make those decisions on their own behalf. The fourth and fifth types of decision support under the new regime relate to future decision supports, and they are enduring powers of attorney and advanced healthcare directives, which I'll touch on later. There are 9 guiding principles under the new Act that healthcare professionals need to be aware of. The first is the starting point for a presumption of capacity. In other words, incapacity has to be proven. The second guiding principle is that a person should be given all possible supports to make the decision on their own behalf. The third is that there is a right to make an unwise decision, so an unwise decision does not equate a lack of capacity. The fourth guiding principle is that there should only be intervention where necessary. The fifth relates to proportionality, and that means that the least restrictive measure necessary must be taken and it must be limited in time. The sixth guiding principle is that the relevant person should be encouraged and facilitated to participate in decision making. The seventh guiding principle is that the views of others in the life of the relevant person can be taken into consideration, so for example their spouse or for example their GP. The eighth guiding principle is that if there is a likelihood of the person regaining capacity, the urgency of the necessity to intervene must be considered. So for example, if someone has a stroke but that they are likely to regain capacity within a relatively short period of time, you need to consider, is it necessary to intervene at this point or can the relevant decision wait? And then the ninth and final guiding principle is that the intervener or the decision supporter can only obtain relevant information to their role. So for example, if a decision-making representative is appointed to make decisions on behalf of another person's healthcare decisions, they shouldn't necessarily need to seek financial or other types of information relating to the person. This Act was commenced on the 26th of April 2023, so it's essential that healthcare professionals are aware of this new Act, particularly those who are working with vulnerable persons who may need some level of decision support. All existing wards, of course, will have their cases listed for discharge hearings within the next 3 years, and in the process of that hearing, the court will decide if the person will need some level of decision support under the new regime. Essentially, an advanced healthcare directive is a legal document which captures a person's future healthcare wishes. It takes effect if the person lacks capacity to make decisions in respect of their own healthcare. The new Act provides rules and guidance around the creation and implementation, and medical professionals need to be aware that the legislation references the possibility of criminal or civil liability where there is a failure to comply with a valid advanced healthcare directive. We've prepared an article on advanced healthcare directives, which is on our website.